And there we go. And I'm going to start. As always, I want to thank everybody who is on for attending. This is our periodic, usually do this every like 2 to 3 months, meeting to update everybody on what has happened or what hasn't happened, as the case sometimes is, in the case with the plan, things of that nature. I will give you a quick summary of where we are financially. And then I will get into the details of what has been going on.
Your meeting ID followed by pound.
All right, I'm going to mute everybody. Let me see if I can do that. I'm going to mute. There we go. All right. All right. So financially, we're just shy of $68 million in the plan, which is an erosion from the last report that I gave to the court of about $4.5 to $5 million. That's typical. As you guys know, we are paying out benefits. The market has been down, and between the payment of benefits and the interest income, which is the only income we have other than settlements, the benefit payments exceed the amount of interest that the plan earns on an annual basis. So we expect an erosion all the time. We expect an erosion unless we get a settlement and an infusion of funds. So we're at about $68 million right now. Benefits, as you know, continue. We're right around the same amount for benefits as we have been. The number trickles up or down depending on certain circumstances, which is somewhere in the vicinity of about $960,000 per month. So we're running at a benefit payment annually of about $12 million, give or take, as well as other expenses related to the plan, such as the PBGC premium and things like that. That's where we are. There hasn't been anything significant in the receivership matter. As you know, the last thing that we did was we went into the court and we asked the court to allow certain trust funds that were in the liquidating receivership to be paid directly over to this estate. That was approved. What those were is those were trust funds that were being paid to the old St. Joe's and old Roger Williams. And because we argued that they were only going to be ultimately benefiting this estate, which was a claimant in that receivership, the judge authorized that the payments be made directly to us, and we've been receiving those. We get somewhere in the vicinity of, Julie, am I correct? It's about $150,000, give or take, every quarter. Is that what we have been receiving?
I believe so.
Okay. I will tell you that I've had discussions with Wistow, Sheen and Lovely, and we are looking into, you guys will recall, back when there was the Charter Care Foundation and there were trust funds there, we negotiated a lump sum payment over to the plan as opposed to taking that trickle on a quarterly or annual basis. We're looking into whether or not that makes sense here as well. At the $150,000, give or take a quarter, is about $600,000 a year coming into the plan. I'd rather grab a substantial portion. I think the funds are probably on their today value is somewhere in the vicinity of about 10 to 12 million. So if we can negotiate a settlement similar to the way we did with Charter Care Foundation, that would get a lump sum of funds into the plan so that those funds can work for you guys now, as opposed to getting those small increments on an annual basis. So I spoke to Wistow, Sheen and Lovely about that. Initially, we started talking about it when we first went in, asking the court to send those funds over to us. And we have had discussions recently about the prudence of doing that and how we would be going about doing that. So you might be seeing something soon being filed with the court in the receivership matter to get that taken care of. Beyond that, the hot off the presses, because we had it emailed to us about, what time is it? It's 5:06. I think it was emailed to us less than an hour ago. Judge Smith in the federal court issued a decision on various motions that had been filed. The diocese had filed a motion for summary judgment on count 4 of the amended complaint, which is in essence saying we don't need to do anything further. You can rule on that right now, Judge, and make a decision on whether or not that count lives or dies. There were also some other determinations that we were asking for in terms of when the plan actually ceased being a church plan. Because I got it less than an hour ago, I haven't read the entire decision. I think it's about 26 or 27 pages long. But I did what I usually do when I read a book is I go to that last page to find out what the hell happened. And I went to the last page, and what the judge did is he granted the motion for summary judgment that the diocese asked for as to count 4. We asked for additional discovery or to expand discovery. And because he denied that count, he said that that was no longer necessary. And he did indicate that the plan ceased being a church plan in April of 2013. Now, I do not know if he said that that's the latest date that it could have, because again, I didn't read the decision. I just went to the back page. I haven't read it yet. So I don't know how he got to that conclusion, or if that conclusion is that's when it became an ERISA plan, or that's the latest date that it could have become an ERISA plan. But be that as it may, if you recall, we argued to him that it became an ERISA plan, a non-church plan at various points, starting in the early 2000s. And we gave arguments for various points. Obviously, with the last point being once I was appointed receiver in 2017, we indicated that it was obvious at that point that it was no longer a church plan. So even if all of our other arguments fail, at the very least in 17, it didn't. He came to the conclusion that in April of 2013, it at the very least ceased being a church plan. He believes, he stated in the conclusion of the decision, that that narrows the issues, and he believes will be my words, not his, a catalyst to get the parties together. He ordered the parties to re-engage in mediation on the issues now that he's rendered this decision to try to resolve it. And if mediation fails, he then spoke about what would be filed next and when and things of that nature. So we will be we'll be posting that decision to the website as we always do. I'll obviously take a look at it. I know Max and his team are probably looking at it right now as we speak, because if I got it at 4:10, they got it around the same time. And so we'll figure out exactly what that means for us. But at the very least, I can tell you that he made that determination on whether or not the plan was an ERISA plan or not as of April 2013. And he granted the motion for summary judgment, thus eliminating claim 4 out of the amended complaint. The impact of the ERISA plan versus church plan date, while it certainly does have an impact on the litigation and how the parties view their respective positions with regard to the litigation, it also will have an impact on what we do or how we make arguments to the PBGC, because it's an indication that although I elected voluntarily to be treated like an ERISA plan in 2000, I think it was 19, although it was retroactive to 17, this is now a determination by the court, the federal court, that the plan ceased being a church plan back in 2013. So that's going to raise a question as to what impact does that have on the PBGC, which would be covering non-church plans. So standard ERISA plans are covered by the PBGC, but from 13 until I made the election in 19, call it retroactive to 17. So from 13 to 17, it should have been treated like an ERISA plan. It should have been paying premiums to the PBGC. It should have been making minimum contributions to the plan for your benefit. And what impact is that with regard to the argument of PBGC coverage? I state that as a more rhetorical question because I don't know the answer as we sit here. I actually have a call scheduled with my ERISA experts for Friday afternoon of this week, and I'll be talking with them about it. They'll have a chance to digest the decision by then, and we can talk about that and what they believe the impact will be. So I know you probably have a lot of questions as to what does that mean for the PBGC. I can't answer that question yet. And in anticipation of questions about the PBGC, I have not spoken to them directly about anything. They have not reached out to us recently about anything. They do typically sometimes on twice a year, sometimes just annually, ask for an update on financial information. The last one, I believe, was in February that they asked for, which we provided. But other than that, there have been no communications from them to us. And the only communication we have had with them is that we forward off all things that are filed and all aspects of this case to them so that they are aware of what's going on in this case on a moment-to-moment basis. So, for example, the decision that was issued today at about 4:10, that'll go on the website and it'll be independently emailed to the various federal agencies, including the PBGC, involved in this case, the Division of, I believe it's the Division of Labor and the Division of Tax, the IRS. So those will probably go tomorrow morning. Other than that, because of the judge's decision today, we've got, well, again, I haven't read it, but apparently it will give us some clarity on a few of the issues. And it has now directed us with what our next step is, which is to re-engage in mediation efforts with the diocese. Because this just happened today, I can't even give you a date as to when those mediation efforts will commence. I would imagine they'll commence quickly, but that's going to depend on the schedule of the mediator, as well as the various parties and their counsel as to what works for everybody. So I wouldn't be surprised. We are in the middle part of September. I wouldn't be surprised if we can convene in mediation within the next 2 to 4 weeks. I would anticipate that that's probably when it will be done, barring some critical or significant scheduling issue for somebody. But I would imagine you'll probably be hearing that we're going to re-engage in mediation probably by the middle, this time next month. I'll call it that, sometime around October 15th, likely. With that, I will open the floor up as I typically do to questions, and I will do my best to answer them. If you have a question, either take yourself off of mute if you can, or raise your hand either physically or electronically. John Burgett is raising his hand, and I just asked you to unmute, John. I think you probably can do it.
Okay. 2 questions. Number 1, excuse my ignorance, but there's a whole bunch of counts in the complaint. What is count 4?
Excuse my ignorance, because I didn't, like I said, I haven't looked at the complaint in a long time. And if you give me, the judge might talk about it. Give me a second and I'll see if he references what the actual count is. But I do not have that at the tip of my tongue.
Okay. Well, I can look it up afterwards. What does that do to the other counts?
The summary judgment on the other, it doesn't do anything to the other counts. The other counts are there. What it does, though, and what the judge said that he believed it did, is it narrowed the issues. Because by eliminating count 4 and eliminating any arguments about count 4, again, we were looking for additional discovery on that and things like that. I think he believes that it has substantially narrowed the issues, which is why he thinks it will facilitate some type of more fruitful discussion than what was had the first time around with mediation.
Thank you.
Anybody else have a question? Wayne, go ahead.
So, some ignorance on my part, what does the recent decision, or how does it relate to whether ERISA starts paying?
Well, that's the question I don't know the answer to. Obviously, if the plan, if according to the federal court, the plan began being an ERISA, not an exempt church plan, back in April of 2013. That means that it was subject to all of the regulations and requirements that ERISA sets forth for plans of this type. That also means that it was eligible for PBGC coverage, and they should have been paying their PBGC premiums starting as early as that time. Now, keep in mind the sale to Prospect happened in 2014. So the date that the court set was approximately, it may not be exactly 12 months, but about a year before the sale happened. So that means before the plan was, as we've used the term, abandoned, because Prospect did not take over the plan and did not take responsibility for the plan. The plan was subject to ERISA. And at that point, because they were treating it like a church plan, it was not, they were not complying with ERISA. Now, how that plays with PBGC, what impact something like that has on PBGC's determination in terms of coverage, in terms of when coverage started, so on and so forth. That's a question I do not know. I might have more clarity on that on Friday when I speak to my PBGC experts. If you remember, I retained the PBGC's former general counsel to advise me on issues related to the PBGC. That's why I have the call with on Friday at about 1:30. And hopefully he can provide some insight, or at least some theories on what that would or would not do with regard to PBGC and its coverage and this plan. I will tell you that one thing that the the date in which the plan ceased being a church plan, typically the way that you identify that time period, that make that determination, is you seek a letter of determination from the IRS, and the IRS will give you that date. In this case, we went to the court, and now the court has said it. It is unlikely, although it's not impossible, but it's unlikely that the IRS will disagree with a federal judge. And they will just take that, which means that it is unlikely that the PBGC will view it any differently either. The question is now, how does that play into a coverage issue? Okay, I hope that answers the question.
Yeah.
John,
does
go ahead.
that
You're still
move-
unmuted.
Does that make your job easier going forward now with the church?
Easier going forward, most likely not. There's never anything that goes easy with the church.
Yeah, I think it's. All right, thanks.
Okay. John, go ahead.
I have a suggestion. It seems that most of us are really interested in what this decision does and or does not do. And you need time to look at it. Maybe my suggestion would be that any discussion as to what the decision does or does not do should be put off to another meeting, maybe in 10, 12 days, to give you a chance to look at it. Because right now you're on a handicap, you haven't had time to study it and consider the implications.
Right.
And you may be saying something that next week you got something else.
That's right. Or that I have clarity on. I will tell you this, is that as it pertains to the diocese, because the judge has now ordered mediation, regardless of what I think this decision does or does not do vis-a-vis the diocese and negotiations with them, I won't be able to talk to that because we're going to engage in mediation. Yep. And I don't want to say anything that will upset that process. However, what I probably can provide some better insight on in the short term, after I read the decision, after I speak with Attorney Cohen on the PBGC issue, is to give you guys a clearer picture about what, if anything, this decision could do vis-a-vis the PBGC.
How much time do you need to do that?
Well, I certainly need until after Friday afternoon, because I got to talk to them first. So I will have read this decision by tomorrow. They will have read this decision before my call on Friday. So I'll have to look at my schedule. I've got a bit of a hectic schedule over the next 2 weeks. But Julie and I will work together and we'll set something on, we'll call it a special meeting. Because it'll be sooner than the next scheduled one. And by that time, we do have a report scheduled for this Thursday. And that report will have been heard as well. So there might be something that comes out of that report on Thursday as well that we can talk about. But with regard to this decision, John, to get right to the question, we'll set something up as soon as we can after I have my call with PBGC council on Friday.
Okay, thank you.
Sure. Does anybody, I know that kind of, that kind of takes the wind out of the air out of the balloon on this one, because now that there's a decision and I haven't had a chance to read it and I can't tell you how it impacts, probably all the questions you guys have are just going to be left in the air. But if there's any questions anybody has, I will listen and do my best to answer. Otherwise, Julie, we can regroup tomorrow and take a look at if there's a date over the next week to 2 weeks that works to schedule another one of these and have a discussion that is dedicated to the decision as well as the impact of that on the PBGC issue.
Sounds like a plan.
Any other questions? Marilyn?
Hi,
Hi.
you knew I was going to raise my hand. How many more times are we going to do mediation with this diocese?
Well, as you know, if this one is ordered by the court, so we don't really have a choice on this one. The
Mhm.
first one we said we would do. This one is ordered by the court. If the court orders it, we can argue if the parties, whether it be the diocese or us, don't think that it is going to be fruitful, we could certainly make the pitch to the judge that we don't think it's going to be helpful. Hopefully, my hope is that this mediation actually ends up resulting in something. So in answer to your question quickly, I hope only one more time because we'll only need this next time. But if it is an unsuccessful mediation for whatever reason this time, then it really depends on whether or not we ever get to a point where we think mediation might be helpful again. I think, though, the judge's decision, with the little that I read in it, and keep in mind, I did not read it, he seemed to be foreshadowing, I want you to try mediation again, because I think this decision is going to force people to focus their efforts a little bit better than they were initially. But he was anticipating that if it fails, he's already got some requirements with regard to how we're going to be going forward in terms of briefing and when that's going to happen and how long those briefs will be and things like that. He put that at the end of the decision as well. So while he's probably hopeful that mediation will be successful, he's already planned for the contingency that it's not. And I think we'll probably just go litigation if it does not, unless the parties collectively think it might be helpful to try a third time if that becomes the case.
By the way, count 4 is declaratory relief for ERISA declaratory relief.
Say that again, John?
Count 4 is declaratory relief under ERISA.
All I heard was declaratory relief under arrest.
ERISA declaratory relief. It's count
Yeah.
4. That's what.
That's what's count 4 is. Yes. Okay. I think you're on mute again, Marilyn.
I am. What
Yeah.
does that mean, declaratory relief? That's like, not speaking English. I have no idea what that means.
With regard to whether or not the plan, I'd have to go back, to be honest, I got to go back and look at the count. Declaratory relief is that we're asking the court to provide certain ruling regarding the ERISA qualification of the plan to give us relief himself on that. But let me go back and look at it. Again, it's been some time since I've actually looked at as you guys know, that complaint is voluminous. It's a very long complaint. It's been some time since I've looked at the complaint. Nothing makes you look at the complaint like a decision by the judge saying that one of the counts is gone.
Thank you.
All right. Any other questions? All right. If there, Deb, are you asking to speak? All right. You're on mute. I asked you to unmute. I know you're driving, so don't get in an accident. We can't hear you.
Can you hear me now?
I can.
Okay, so this is a bad thing for us? Like, I'm thinking this is not good. Or can we just pay the insurance premiums back from 2013?
That
Like,
I
what
don't
am I
know.
going?
Yeah, that I will have clarity on that question, because that's a question that I have. Is
Oh.
this merely, is this merely, all right, though, you got a federal judge saying that the plan was not a church plan and therefore was qualified under ERISA and was required to comply with ERISA in 2013. Is it as simple as calling the PBGC up and saying, how much are the premiums? And we'll pay you those. And now we are qualified and now we can do what we have to do with regard to protecting this plan? Or is it not that simple? My assumption is going to be that I'm going to be told on Friday it is not that simple, but I don't know the answer to that question as I sit here today.
So being not a church plan, that's in our favor. Correct?
Correct. We have been arguing that this was not a church plan before the receivership. So we argued it was certainly not a church plan once the receivership started in 2017. It was clearly not a receivership. I mean, not a church plan then. But we have argued that it was a church plan. It was not a church plan. It ceased being a church plan even before that. And we gave arguments for various points from the early 2000s up through 2017. And the arguments were different at each point. But we basically said, look, we don't think it was a church plan in 2008, and here's why. And if you disagree, then we think it ceased being a church plan in 2010, and here's why. And if you disagree with that, we think it ceased then in 2013, and here's why. And we kept going all the way up until 2017 when the receivership started. Because the receivership argument was, at the very least, once a receiver was appointed, it ceased being a church plan, and nobody can argue that. And nobody has argued that. Everybody was in agreement, Prospect, the diocese, everybody, that once the receiver was appointed, it ceased having church plan status. It's just the arguments before that. Marilyn, did you have your hand up again?
I did.
So I'm
So why do we have to pay back to 13? Why doesn't the diocese have to pay? They were the ones who didn't pay.
I'm not saying we would have to pay, and I think that's part of the reason why we're going to mediation now. And I think that might be, without having read the decision from cover to cover, that might be what the judge was thinking in terms of saying, I think this decision now narrows the issues and will bring the parties to a place where a mediation could be meaningful. So I'll leave it at that. I don't know what the mediation will result in, but clearly I was not in play in 2013, 14, 15, 16. So regardless of how badly I may have wanted to, I could not have paid those premiums then. And until this decision, even if you could pay premiums retroactively, until this decision, the PBGC wouldn't have accepted payments as far back as 13, 14, 15, and 16, because they only allow retroactivity back, I think it's either 18 months or 24 months, which is why when I filed, I went back as far as I could with retroactive application. So we're in a new place right now with this decision. Like I said, it came out about an hour ago, and it's changed the landscape. The problem is, let's say this, I don't have my glasses on yet to see how it changed the landscape. I just can tell that it's changed. I'll have my glasses on within a week.
Good. So we can expect another town hall.
Yeah, I'll
Okay.
work with Julie to find a date that works for my schedule. And then we'll get it scheduled and notice out to everybody so that you all know about it the same way as you know about these. All right.
Is it possible that the federal government can penalize the diocese for evading if they deem it should not have been called a church plan? Could they penalize the diocese for evading paying
don't.
those taxes?
I don't know the answer to that question. That's part of what I'll probably be discussing on Friday. Because like I said, we've been arguing that we've been in this realm, but we've never been squarely here. There's been arguments, but now we actually have a date that a federal judge established it. Okay. Deb, it looks like you stopped driving. I hope you did. You're on mute still. There you
Am I
go.
unmuted?
Yep, you are.
Okay, well, I was not getting reception. I was in and out, in and out. So I pulled over to Cumberland Farms. I'm
Oh.
thinking that this is a bad thing for us.
Why are you thinking it's a bad thing for us? To be honest with you,
Because,
getting a determination by a federal court that this plan ceased being a church plan well before, not a couple of days before, not a couple of years before, but even before the sale happened. It may not be 2008, which I think would have been better for certain arguments, but it certainly wasn't saying, no, it was a church plan.
Right.
The fact that everybody said it was a church plan, that's fine. This creates a scenario for everybody that has a little bit of all right, what do we do now with this? The church was still, the diocese was still in control of the hospital and the plan back in 2013. The sale had not yet happened yet. There are implications to this, and we were arguing, and we wanted, in that sense, we wanted the court to make a determination. We had hoped the court would make a determination that the plan ceased being a church plan prior to the receivership. They had considered it a church plan all the way up to that point. This actually now resolves that issue and says, nope, everybody who thought it was a church plan up until Steve was appointed, you were wrong. It actually ceased being a church plan at least 4 years before that. And that's 4 years that there should have been money going into the plan. That's 4 years that premiums should have been paid. That's 4 years that you as pension holders should have been getting certain notices required by ERISA about the health of the plan, about the assets, about the contributions. So there are issues for the people who were in charge prior to 2017 with this ruling. How bad those issues are, or what that results in terms of a discussion, whether it be at mediation or in the court, I can't answer that right now, but it certainly creates a discussion about it. You're still muted, or you're muted again.
sorry, I'm here.
Okay.
I'm having interference coming in and out because I'm up in Slatersville and it's cloudy and whatever. But so maybe this will force the Catholic Church, the diocese, to give us more money with our settlement.
I mean, I would certainly, my hope is that they will offer more money than what was offered the first time we went to mediation with them.
Right. Because
They are
now
probably looking at this and saying that my ask, which was much, much higher than what they were offering, will come down. So I think the judge is looking at this as we were universes apart the last time, maybe we're in the same solar system now and we can land on the same
Okay.
planet at some point.
So by this, so what I'm thinking is by this judgment, Judge Stern is saying, you know what? We caught the Diocese of Providence with their pants down, right? Because it wasn't a church plan prior to what we thought was when this whole fiasco of August, was it August 19th of 2017 of the nightmare when it all began, correct?
Well, this was Judge Smith, by the way, not Judge Stern. This
I'm
is
sorry.
federal court.
Oh, Judge
No, that's
Smith.
okay.
Okay.
And
So this is the
I,
federal, I'm sorry, this is
yeah.
the federal court. I'm
Yeah.
sorry. I
and I don't
apologize.
know if the diocese would agree with you saying that this shows that they got caught with their pants down. You know, I
Oh, that's
can't.
funny. In more ways than one. I'm sorry.
And I can't even comment on that either because, like I said, until I read the
Okay.
full decision, I can't.
Okay.
I don't even want to begin to surmise the tone or the direction that I think the judge was going in. You know, I read one paragraph on the last page of a 26-page decision because the
And you know what
decision
else?
was emailed to me while I was driving to get on this Zoom.
You know what else bothers me though, Steve? All of these years when the economy was great and the market was wonderful, we could have been making really good interest on that money. So they should be also, that should also go into play with this settlement of the Catholic Church. I'm
I will-
sorry.
I will
Because
tell you,
that-
Deb, that's already been in our discussions internally. All of those things are on the table. The diocese knows that.
okay,
We know that. I mean,
okay. I'm not trying to tell anybody how to do their job. I'm really not.
no,
you
no,
know,
no. And I don't take it that
you
way,
know,
but just understand I am aware as well as Wisto, Sheen and Lovely. We are all aware of if something was supposed to be done in 2013 that wasn't, if
Yeah.
money was supposed to be put in and it wasn't, that means that from 13 until 17 when I was appointed, there's interest lost. I mean, there were losses during those years that could be predicted, but there were also gains. And so we'll have to look and see what the net effect of that would have been had that. You can figure that out. Now, sitting here today in 2022, we know what the market did in 13 and 14 and 15 and 16, and we know what would have happened to money that was invested in certain vehicles at that time.
Right.
On that market. It's not hard to plug in those numbers and then figure out where it would have been had that money been there. I just, as I sit here right now, I don't know whether or not that number is a positive number, a negative number, or a break-even number. All I do know is that every year under ERISA, you're supposed to fund the plan to a minimum funding requirement that your actuary identifies for you, and that was not done. We all know that was not done. So that's one fact that we
Then
know.
our actuaries, we got rid of them because they weren't doing their job correctly. That was, I forgot that company. We got rid
That
of
was an
them.
Angel Pension, and I can't.
Angel Group.
We settled with them, so I will not characterize
Oh.
what they did or didn't do because we did enter into a settlement with them.
It's a mess.
Well, we're trying to unmess it. We've been trying to unmess it. Wayne, I can't hear you, Deb. You're not on mute, but I can't hear you.
Am I off?
Yeah, nope, you're on, Wayne. Deb, we can't hear you. I don't think she can hear me either.
No, I don't think so.
No. Go ahead, Wayne.
Can you share with us what you had for an offer and what the church had for an offer during the first mediation?
I cannot. Unfortunately, I cannot. The discussions at mediation are confidential.
Okay.
All right. I can tell you that what I started at and what they came back at, both sides were extremely disappointed with what the other side came to the table with. So it was
far
It
apart.
wasn't even the media. I will tell you, even the mediator, the reason why we stopped is the mediator said, you guys are so far apart, it's not even worth continuing into a second day.
Yeah.
So that's where we ended off. We were multiple universes apart at that point.
Okay, thanks.
Sure. Anybody else? All right, with that, I'm gonna say goodnight to everybody. Julie and I will figure out a date for the next one in short order. And we will get that notification out for you. So where I normally say I'll see you in a couple months, in this case, I'll say I'll see you in a couple of weeks at a max. All right. Have a good night. Be
Sounds good.
safe.
Thank
See
you.
you soon, everybody.
Thank you.
Thank you.